Hi. Also here. Welcome and good evening. I'm James Sparrow. I'm a member of the history faculty and the director of the Democracy Corps, which is the co-sponsor of tonight's event. The other co-sponsor is Classics of Social and Political Theory, sort of a sister sequence who shares sensibilities and texts with our sequence, and they played an important role in informing where we went with the new Democracy Corps. Before I get started, I'd just like to make a few announcements while I have you here. First is that just under 3 weeks from today, on Monday, February 26th, Nathan Pearl Rosenthal will give a talk on his new book, The Age of Revolutions and the Generations Who Made It. That'll be in Social Sciences 122 at 5 p.m. Those of you who've been reading Palmer's Age of the Democratic Revolution, the talk should give you some fresh insights since Palmer's work came out in late 1950s, early 1960s. Second announcement is that we're accepting undergraduate members for the Student Advisory Board for the Democracy Corps. So if you're interested in democratic issues, big or small, and would like to join with your students and planning events, speakers, movie night, you name it, we welcome your participation. We'll send a follow-up message after the talk so that if you'd like to sign up. And then finally, cookies are available in the center of the room. We welcome that you take as needed. And finally, I just want to thank the people who have helped make this event happen. Dara Grant, who I think is in the back, the co-chair of Classics, and Kevin Cromash and Laura Sandino. Kevin and Laura, just right there. They do a wonderful job running the democracy curriculum for us. So you can find a full description of the democracy curriculum on the website, democracy.uchicago.edu/democracy curriculum, and I encourage you to check it out. So I should introduce our speaker so we can get on with our evening. He's currently teaching a section in the Democracy Corps. His name is Clifford Ando. Professor Ando is David B. and Clara E. Stern Distinguished Service Professor. He's chair of the Classics Department and professor in history in the college at the University of Chicago. His research focuses on the history of religion, law, and government in the Roman and post-Roman worlds. And his books include Imperial Ideology and Provincial Loyalty in the Roman Empire, The Matter of the Gods, Law, Language, and Empire in the Roman Tradition, and Roman Social Imaginaries. So without further ado, please join me in welcoming Professor Ando.
Thank you very much, Jim. It's a great pleasure to be here. I'd say, in addition to teaching at the moment in the Democracy Corps, I have taught twice in Classics of Social and Political Thought, both times in the winter quarter. So there is a sense in which I am well situated to lecture to both sequences at once. And I firmly believe that they belong in conversation with one another. That said, I have to offer two caveats. First, I'm not a historian of the early modern period. I'm an enthusiast rather than an expert. And at the moment that I was invited to do the core lecture, I was told that the lecture should focus on material that is currently on the syllabus. And I had to point out that at the moment I was invited to do this, there was in fact, I think, no reading in common between the two syllabi. So Leviathan was added to the democracy syllabus because of this. I should also add that I've never actually gone to a core lecture. But I hope that what I've tried to do in this is appropriate to the occasion, but we shall see. What I'd like to do is discuss a set of themes that are obliquely related to both sequences, be a material that commences in antiquity and ends in the 19th century. And in so doing, I hope to make up for some deficiencies in expertise with a kind of genuflection before the ideology of the core. Oh, there we go. In what follows, I commence with some abstract remarks about tensions in the practice of politics, and more particularly in the relationship of law to the state. These exist in two domains that are of interest to me today. First, legal legitimacy, namely the question of whether law has to originate with the people in order to be legitimate. And if that is so, does that mean that only democratic states can properly have the rule of law? And second, the question of whether polities that exist within empires can be said to have their own law. After those abstract remarks, I'm going to read some text from the tradition as imbricated in these debates according to the schema before you, according to the outline. None of the issues that I'm going to raise in the lecture was even remotely resolved at the end of the 19th century. And so you might say, I've arranged for some teachers in the court to be present today, ones with actual expertise in the early modern and modern periods, to be present to answer any questions you might have. Call on all of you at the appropriate occasion. So, I want to start by illustrating via texts from nearly the poles of my inquiry the basic problem that I want to interrogate. In the Communist Manifesto, Marx drew attention at a critical juncture to the importance of private law as an instrument of domination. But don't wrangle with us so long as you apply to our intended abolition of bourgeois property the standard of your bourgeois notions of freedom, culture, law, etc. Your very ideas are but the outgrowth of the conditions of your bourgeois production and bourgeois property, just as your jurisprudence is but the will of your class made into a law for all. A will whose essential character and direction are determined by the economical conditions of existence of your class. Political power, properly so called, is merely the organized power of one class for oppressing another. The political class crafts law to serve its own interests, Marx avers. This is why government is the most potent means ever devised for the transfer of wealth from the poor to the rich. The implication is naturally that a more inclusive process for lawmaking might result in a body of substantive law that reflects a wider array of interests, or is less asymmetric in how it figures justice. 2,000 years earlier, in On the Commonwealth, Cicero offered a strong claim that connected democratic lawmaking with justice and asserted that on this premise, legal legitimacy could only be realized in the state of a strongly democratic form, in which deliberation was conducted in an assembly of citizens and citizens were equal before the law. And so, Cicero writes, even if Cyrus the Great was the most just and most wise of kings, Persia under Cyrus still does not seem to be a very desirable concern of the people, for that is what I called the Commonwealth earlier, since it was ruled by the decisions and will of a single man. On the same grounds, although our clients, the people of Marseille, are ruled with the greatest justice by chosen leading citizens, the condition of the people still involves a semblance of slavery. And so in no other state than that in which the people has the highest power does liberty have a home. Liberty than which nothing can be sweeter, and which, if it is not equal, is not even liberty. And therefore, since law is the bond of civil society and rights under law are equal, then by what right can a society of citizens be held together when the status of citizens is not the same? Even if equality of property is not appealing, and if the mental abilities of all cannot be equal, certainly the rights of all who are citizens of the same commonwealth ought to be equal. What is a state, if not the voluntary association of citizens under law? In my lecture today, I consider the long history of normative theorizing on legal legitimacy. Are we only legitimately regulated by law if we had a role in approving it? and in particular, its connection to the form of the state. Does one have to have a democratic state to have democratic law? Posed in these terms, the answer might seem so obviously yes as to invite the question, why are we here? And of course, one might surmise that I posed the question at the start of the lecture because the answer must be no. And then you can now sit back and hope that I can demonstrate and resolve the paradox at the heart of the topic in a fashion that justifies my claim on your time. So here we go. It's worth bearing in mind that both classics and the democracy of core began the term by engaging a text that made an emphatic claim that all citizens are equal authorizers of the sovereign and therefore of their sovereign's law. And this held true regardless of the neo-Aristotelian form of their state. A commonwealth is said to be instituted when a multitude of men do agree in covenant, everyone with everyone, that to whatsoever man or assembly of men shall be given by the major part the right to present the person of them all. That is to say, to be their representative. Everyone, as well he that voted for it as he that voted against it, shall authorize all the acts and judgments of that man or assembly of men, in the same manner as if they were his own, to the end to live peaceably among themselves and be protected against other men. Hobbes emphasizes throughout these foundational chapters that everyone who covenants is the author of each act of the sovereign, regardless of the form taken by the state. So again here, man or assembly of men. And everyone here probably recalls that Hobbes deemed the question of the relationship of the form of the state to its legitimacy sufficiently important that he devoted the bulk of chapter 14 to precisely the topic of the several kinds of commonwealth by institution. Nevertheless, he was indifferent among the choices as regards legitimacy, even if he did express a preference as regards something like efficiency or effectiveness. Now, a question begged by much of the normative theorizing that we read in the core is the legitimacy of law and indeed of government in context of empire. Both the legitimacy of local law when ruled by a state that imagined itself to be a democracy, and the legitimacy of local law when one's own state or one's own local state was democratic but not free. I say the question is begged because it seems pretty obvious that a central object of the contractarian tradition of all this writing about contract in the state of nature and forming a polity ex nihilo is precisely to avoid the topic, undoubtedly because empire was the context for the emergence of, on last estimate, something like every state that we study, and perhaps even every state that is named in every text we read over these two terms. I'm going to return in closing to what Hobbes has to say on this topic. And near the opening of the 18th Brumaire, Marx urges that the trappings and language of the French Revolution and its democracy have been fashioned from Roman materials. Consideration of this conjuring up of the dead of world history reveals at once a salient difference. Camille, Desmoulins, Danton, Robespierre, Saint-Just, Napoleon, the heroes as well as the parties and the masses of the old French Revolution performed the task of their time in Roman costume and with Roman phrases, the task of unchaining and setting up modern bourgeois society. The classicism of the moment also struck Benjamin Constant, who was equally skeptical about the fit between classicizing notions and contemporary realities. But I want to focus for a moment on Marx's perception that it was Roman language that mattered. For one thing, as you know, the Greek term democracy does not mean government by the citizen body, but domination by the poor. It's the term arche or archia that means government, among other meanings it carries, Hence, the vocabulary of Greek normative thought in its etymology tips its hat to elitist preferences in suggesting that rule by one person is government, monarchy. Rule by the few is government, oligarchy. But rule by the poor is domination. What is more, the term krateo is transitive. Democracy is domination by the poor of someone else, namely the rich. This ineluctable sense that the point of government was to take other people's stuff is the background to the extraordinary instability of Greek government in antiquity, at least outside Athens. A recent estimate urges that Greek city-states suffered periods of civil strife and oscillated between oligarchy and democracy on average every 30 years. And that the world of Aegean city-states was subject to something like 5,000 instances of stasis, of civil strife, in the classical period alone. Stability often emerged in efforts to balance elite and mass interests under conditions of what we might call diarchy, where we see decrees of city-states identifying sovereignty as lodged in the council and the demos. It is also the case that Greek lacked, as also Latin lacked, a unitary conception of sovereignty. Greek thinkers evaluated the conditions of polities according to two analytic axes. Did they have freedom of action in foreign affairs? Did they have eleutheria, freedom? And did they have autonomy, which meant no more and no less than the right to use their own body of locally generated private law? I'll return to this issue at the end of today's lecture, but this ability to value and possess autonomy, that is, your own private law, under conditions in which one was not free, helps to explain why democracy was often the favored form of government by ancient empires for subject polities. When the Persian Empire first conquered the Greek cities of the Eastern Aegean, for example, we are told by the contemporary witness Herodotus that they systematically deposed oligarchies and instituted democracies. That may not be the conventional story about why the Greeks took up democracies, but they did it at the point of a gun. Or whatever it is, like a spear, whatever it is. So the title of my lecture today, Law is What the People Commands, is one of a number of very similar formulations offered by Roman politicians and above all, Roman legal theorists. Here, for example, is a definition cited in a literary dialogue of the 2nd century CE, taken from a jurist who wrote under the first Roman monarch, Augustus. Here it is asked what a lex, a statute is, what a plebiscite, what a rogatio, what a privilegium. Ateus Capito, who is most learned in public and private law, defined what a statute is in these words. A law, a statute, he said, is a general command of the people or plebs when a magistrate puts a question. The term plebs points to an early division in Roman society between two classes, an aristocracy of blood and all others, which must in origin have corresponded with a rush division of the Roman society into elite and non-elite, or you might say into elite and demos. Its presence here gestures to the fact that Roman practice came to recognize norms voted on in an assembly comprised solely of the plebs as binding all citizens. They didn't call these statutes, but rather plebiscites. Now you might wonder why I cite a definition of law as originating in the popular assembly from a theorist in the age of monarchy. For one thing, it is simply as a matter of chronology. It is from the age of monarchy that the great bulk of Roman jurisprudence survives. But context does matter, and it is from the age of monarchy that nearly all attributions to the people of plenary power in the Roman State happen to survive. And here's why. The most famous and influential invocation of popular sovereignty as expressed in democratic lawmaking to survive from the Roman tradition, one enormously influential on the early modern world, is that offered by the jurist Ulpian in the early 3rd century CE. A decision given by the emperor has the force of statute. This is because the people commits to him and into him its entire power of command and capacity, doing this by the royal law, the lex regia that is passed concerning his imperium. Therefore, whatever the emperor has determined by a letter over his signature, or has decreed on judicial investigation, or has pronounced in an interlocutory manner, or is prescribed by an edict, is undoubtedly a law. Here. These are what we commonly call constitutions. Please observe that in Roman constitutional law, magistrates were invested with the power to command citizens not via election, but through statute. Hence, according to Ulpian, the creation of the emperor as emperor took place through a vote of the citizen body to approve or not approve a law. This is actually a wild inaccuracy as regards something like the first 100 or so years of the monarchy, but I'll set that development aside. It's from this expression of sovereignty by the citizen body as a whole that the emperor's ability to create law derives from this theory. Now, just as there were multiple sources of law at Rome, including both the citizen body as a whole and the plebs, and in some readings, the Senate and so forth, just so, no single theory of sovereignty commanded universal and long-term assent under the Roman Republic. That said, it was reasonably common on legal instruments to represent Rome as a diarchy, as here. Lucius Aemilius, the son of Lucius, commander, decreed that the slaves of the Hastenses who live in the Tower of Lusitana should be free, and the field and city that they possessed at that time, he commanded them to possess and to have so long as the Roman people and Senate shall wish. It is only in the very last decades of the Republic that one finds assertions that the people held plenary power in the state. But commencing from the reign of the Emperor Augustus in texts like Ateus Capito, it becomes routine to describe as always Rome as always already having endorsed a strong principle of popular sovereignty in the following form. This is the final clause in the law passed in the final weeks of the year 69, or perhaps in the year 70, granting specific powers to the new emperor of Rome, Vespasian. Vespasian came to power as the result of a civil war that erupted in the year 69 as support for the emperor Nero collapsed. 4 people led armies on Rome to contest the throne. Vespasian was the last one standing, but 4 different persons had been acclaimed emperor over the course of the year, as each in succession held the throne, and as each in succession held the throne, the actions of the others were, strictly speaking, illegal. The question arose how to retroactively deem legal actions taken by Vespasian when he had been merely a usurper. One possibility not taken by the authors of this law was to employ the fiction that all of his prior acts should be treated as if he had been emperor from the date when his troops gave him the title. And Roman law uses fictions of this kind all the time when somebody makes a mistake about their status. Instead, the text employs a different legal fiction. And the entire text will have begun with some sort of announcement. The and that refers to the fact that there's some initial verb of the form, the so-and-so decrees. And then they decree what? They also decree that. Those things that were done or performed or decreed or ordered by the Emperor Caesar, Vespasian, Augustus, or by anyone on his command or mandate before the proposal of this law, they are lawful and binding exactly as if they'd been done by command of the people or plebs. So what the emperor did was exactly as lawful or binding as if this were a republic and the people had ordered it. Or rather, what the emperor did was exactly as lawful and binding as if this were the sort of republic in which sovereignty were simple and unitary, and so forth. The messy history of doctrines of sovereignty under the Roman Republic is thus being rewritten right before our eyes in the service of monarchy. Now, despite the disquiet that Roman evidence might induce, disjoining as it does any simple connection between the principle of democratic legal legitimacy and popular sovereignty, the two ideas are obviously deeply imbricated in many contexts, and indeed can often be said to co-validate each other. For example, the second of the resolves of Fairfax County, Virginia from 18th July, 1774, which some of you read this term, asserts as axiomatic the claim that to be governed by laws to which one did not consent was tantamount to slavery. Resolve that the most important and valuable part of the British Constitution upon which its very existence depends is the fundamental principle of the peoples being governed by no laws to which they had not given their consent by representatives freely chosen by themselves, who are affected by the laws they enact equally with their constituents to whom they are accountable, and whose burdens they share, in which consists the safety and happiness of the community. For if this part of the Constitution was taken away or materially altered, the government must degenerate either into an absolute and despotic monarchy or a tyrannical aristocracy, and the freedom of the people be annihilated. Cicero is nodding consent. Reflecting on the impact of having actualized such principles in the design of government, Tocqueville suggested that a people that understood itself as the authors of the law would bring into being a self-sustaining democratic culture, in which government was regarded as a merely human institution and the head of state regarded as merely a magistrate. The same principle is evoked in different terms in the Declaration of the Rights of Man and Citizen. The law is the expression of the general will. All citizens have the right to take part in person or by their representatives in its formation. It must be the same for everyone, whether it protects or penalizes. All citizens begin equal in its eye. All are equally admissible to all public dignities, offices, and employments according to their ability, and with no other distinction than that of their virtues and talents. From there, the idea was available to be mobilized as norm in support of arguments on behalf of the participation of free blacks in government. Here, for example, is Abbé Grégoire in a pamphlet written in the fall of 1789. The people of color being equal in everything to the whites, one will surely not ask if they should be active in legislation and send deputies to the National Assembly. Subjected to the laws and to taxation, citizens must consent to the one and the other, without which they can refuse obedience and payment. And free blacks in Haiti cited the same principle that they should properly participate in and assent to any legal proceeding that bore on their rights. Article 5. We request that our class be duly and legally invited to take part in the decision regarding our rights, as once they are stated and fixed, following our assent and the sanction of our fathers, these rights will determine our future and that of our descendants. All these documents assert that for the law to be legitimate, those regulated by any given law must participate or be represented in the relevant lawmaking procedure. In each case as well, the through line from democratic lawmaking to democratic sovereignty is clear. But law is made in other ways than by legislatures. I focus now on two contexts that generated doctrines of legal immanence, namely two contexts in which norms were understood to be abstractions from the simple patterns of social economic conduct of persons in society. The two contexts are England and Germany. As you'll see, I might as well anticipate my conclusion by saying that these are contexts in which the people are asserted to be the sources of the law, but people are deeply skeptical of whether that means you have to have a democracy. So these are texts that are vastly more skeptical about the relationship between lawmaking and democracy, and that may be why texts like these are actually not in the democracy core. So you'll have to, these are not readings that you're otherwise going to encounter, or at least most of them are not. In England, of course, the common law was understood to be articulated through the aggregation of judicial decisions that themselves sought to abstract principles of correct ordering from the raw material of human conduct, always in light of earlier adjudications. Unsurprisingly, within such an ideology, it was possible to make strong claims for the autonomy of law from any given political order. A famous example is provided in an account by Edward Coke, Chief Justice of the Common Pleas, of an argument between himself and James I. A controversy of land between parties was heard by the king, and sentence given, which was repealed for this, that it did not belong to the common law. Then the king said that he thought the law was founded upon reason, which is itself a totally reasonable reaction to the encounters of common law of property, and that he and others had reason, as well as the judges, to which it was answered by me that true it was, that God had endowed his majesty with excellent sense and great endowments of nature, but his majesty was not learned in the laws of his realm of England, and causes which concern the life and or inheritance or goods or fortunes of his subjects are not to be decided by natural reason, but by the artificial reason and judgment of law, which law is an act which requires long study and experience before that a man can attain to the cognizance of it. But of course, while such a doctrine might be a shield against other actors in the political firmament, arrogating to themselves the right to make private law, it emphatically could not generate an argument in favor of a particular political form for a lawmaking institution. In consequence, although English voices occasionally brought forward strong claims that sovereignty existed in some residual fashion with the people, as here, since you have done the nation so much right and yourselves so much honor as to declare that the people under God are the original of all just powers. We're here. Now, sir, the commons of this nation, having empowered their body representative whereof you are one, with their own absolute sovereignty. And although the claim by William of Orange that his invasion was intended to vindicate the laws, liberties, and customs of England, because these had an ontology distinct from the occupant of the kingship, no meaningful claim on behalf of democracy as a form of the state, based on the principle that the people were the originators of the law, was ever made in our period, or so it seems to me. A remarkably similar doctrine about the immanence of law was made in 19th century Germany. Now, Germany in this period was not unified. It was a region of small principalities. But it had been given a taste of the efficiencies and rationality to be gained from having a unified law code in the very brief period when Germany passed under French domination and was forced to use the Code Napoleon. A debate arose whether to craft a shared body of law, or actually rather stunningly, even whether Germany should adopt or re-adopt the Napoleonic Code. It seemed especially palatable now that Napoleon himself was locked away. The most famous voice on the side of non-codification was the jurist Friedrich Karl von Savigny, during his lifetime, surely the most famous legal theorist in the world. And despite the fact he wrote exclusively in Germany, if you do a search of American judicial decisions of the 19th century, Savigny is cited, I think, probably more than any other legal, even an American legal theorist. He completely dominated thought on law in something like the thing we call the globe. He's really a figure of really remarkable influence. That despite the fact that what he writes is mostly insane. So sort of straighten it out. Savigny argued that the substance of the law was drawn from the entire past of the nation. He uses the term several times. But his favorite term, unsurprisingly, was das Volk, which had cultural rather than political valence. And it's important, of course, to have a term like folk, because as I say, Germany was not unified. There was nothing like a citizen body to which you could attribute authority. If we further ask about the subject in which and for which positive law subsists, we find the people to be that subject. In the general consciousness of a people lives positive law, and hence we have to call it people's law. And then later, rather, it is the communal Volksgeist, spirit of the people, living and operating in all individuals, that engenders das positive Recht, which gives rise to positive right. For the consciousness of every individual is not accidentally, but necessarily one and the same. So you can see what I mean, that Savigny somehow managed to be against the unification of Germany and nevertheless a totalitarian unity. Savigny was willing to countenance the claim that a people should map a state and vice versa. But because the ontology of the law was metaphysically distinct from that of political institutions, he professed a complete indifference to the distribution of political power, and even he claimed of legislative authority. It is also entirely erroneous to regard this position of the legislator as dependent upon the different arrangement of the legislative power in this or that constitution. Whether a prince makes law, or a senate, or a larger collection of the people, perhaps formed by election, or perhaps the agreement of several such powers is furnished for legislation, the essential relation of the legislature to the people's law is not at all changed. In short, neo-Aristotelian analyses of the form of public power and modern concerns about legal legitimacy are alike answered by an appeal to the organic status of peoples and their states. In consequence of this view, Savigny treated constitutional law as simply external to the science of private law. So, in both England and Germany, it was emphatically the people who made law, but they did so simply by going about their business, while one king replaced another and Prussia conquered the world. I mentioned earlier that democracy was regularly the form of local government preferred by ancient empires, Persian, Athenian, and Roman. With the caveat, of course, that Persia and Athens instituted Greek-style democracies, while Rome designed republican constitutions along principles of popular sovereignty. I also drew your attention to the non-existence in the ancient world of any unitary theory of sovereignty. Instead, I argued that in both Latin and Greek, one constructed something like our sovereignty from a bricolage of concepts, most especially that of freedom of action in foreign affairs and autonomy, or the right to use one's own system of private law. This slide contains the text of a settlement imposed by a Roman general on an Iberian community that had just performed an unconditional surrender after military defeat in the year 104 BCE. The language recalls, of course, the Roman document from Iberia in 189 BCE that we read earlier. I'll translate the text in bold only. Then Lucius Caesius, son of Gaius, imperator, general commander, ordered them to be free. And the land and buildings and laws and all other things that were theirs on the day before they surrendered themselves, he gave back to them so long as the Roman people and Senate wish. Observe again the diarchic formulation employed to describe the location of plenary power in the state. It is the Roman people and the Senate. Please note as well the decisionist nature of the power that Rome claims for itself. It reserves the right to reform, revise, or remove the rights of the Iberians on any grounds whatsoever. But this document also differs from the earlier, this document just plain differs from the earlier one in one notable regard, namely the inclusion of laws among the things that the Roman general gave back. In Greek terms, this polity was autonomous, but not free. We possess from the Roman Empire dozens of decrees by local polities offered in the name of the people or the council or the demos, or both, that is both people and demos, and addressed to the emperor upon his accession, thanking him for reconfirming what had become a long-standing right to use their own laws. Grants of autonomy were, I suggest, an instrument of ideological power, provoking as they did expressions of gratitude that effectively acknowledged the right of Rome to bestow or withhold autonomy. And in so doing, all these people crafted themselves as subjects of empire. Reflecting on the world created by a quarter millennium of practice along these lines, the Roman jurist Gaius offered the following theory definition of civil law, which phrase in Latin is perhaps better translated citizens' law. That is, the term civilis is simply an etymological descendant from citizen. All peoples who are governed by statutes and customs partly observe their own peculiar law and partly the common law of all human beings. The law that each people establishes for itself is peculiar to it and is called jus civile, being, as it were, the special law of that civitas, which is an abstraction that just means citizen body. The heavy lifting in this text is done by the distributive pronoun each and the reflective pronoun for itself. Gaius here, and so is distributive across the land. If it exists in each city, it therefore exists in every city, which is to say, every city or every city-state has its own law. A semi-official list of the city-states of the Roman Empire counts about 2,000 such polities. And so we are to imagine there having been something like 2,000 separate codes of private law in the Roman Empire. What is more, on Gaius's representation, in each city-state, law is made democratically by the citizens. The term populus, which I translate people, is a term of art in Roman law for the citizen body. In short, broad subscription to a theory of democratic legal legitimacy was the sop by which local acquiescence to imperial domination was purchased. 1,500 years after Gaius, Hobbes reflected on such situations in chapter 26 of Leviathan, the chapter entitled Of Civil Laws, and came to a very different conclusion. I cite here the fifth of his deductions, namely that in contexts of sovereignty by acquisition, provincial laws are not made by custom, but by the sovereign power. If the sovereign of one commonwealth subdue a people that have lived under other written laws, and afterwards governed them by the same laws by which they were governed before. If you were Roman, you would say, if you were governed by the same laws as you were on the day before conquest. Yet those laws are the civil laws of the victor, and not of the vanquished commonwealth. For the legislator is he not by whose authority the laws were first made, but by whose authority they now continue to be laws. And therefore, where there be diverse provinces within the dominion of a commonwealth, and in those provinces, diversity of laws, which commonly are called the customs of each several province. We are not to understand that such customs have their force only for the length of time, but that they were anciently laws written, or otherwise made known for the constitutions and statutes of their sovereigns, but are now laws, not by virtue of the prescription of time, but by the constitutions of their present sovereign. Hobbes strips the practice of empire of its illusions, and in doing so, reveals one function of doctrines of democratic legal legitimacy. Not the only function, of course, but an important function, to make democratic polities comfortable in situations of non-freedom. And that is my concluding and non-comforting thoughts. Thank you for your attention. But I'm happy to answer big questions or talk. Right. Obviously, it's something like the end of the 18th century. There were a whole bunch of people in the United States who believed in something like democratic legal legitimacy. That's because they hadn't heard about legislative capture yet. I could treat this like class and call on someone. Yes, sir.
This may be like sort of a minor question, but like with Savigny and the invocation of like the Volksgeist,
Yeah.
it almost read Hegelian in a certain sense. Could you speak to which has its own kind of thing of it seems to be almost an apology for democracy, but also has been an apology for non-democratic movements. So could you just speak to that?
Yeah, I mean, the context helps to generate the resemblance. Although people after Savigny, so people after this, I mean, this is a huge deal in Germany, because in essence, right, this moment in the late teens and 20s is a moment when they were forced to imagine the possibility of writing their own law code. And of course, it raised the question of the unification of the German state. So anytime they talked about law, there were many other big issues in the air. It's also to be remembered about law just as a culturally privileged way of speaking, that in many of the separate polities of Germany, and in an emphatic way, starting a couple of decades later, a degree in law becomes a necessary qualification for most civil service jobs, and something like, almost all posts in Germany. But here there's a kind of, I take it that it's precisely the situation of Germany is not yet unified, that helps to generate a kind of agnosticism in at least a bunch of these people about something like Aristotelian form. Now for Savigny, right, so that they have this doctrine of the people's law, and it has a variety of different theoretical justifications and a variety of different purposes to which they put it. But for the lawyer, and not to speak strictly about Savigny, there was also a sense in which I should speak not generally of lawyers, but narrowly law professors. Law professors had an important function in adjudicating questions of civil law. There was a set of institutions widespread in Germany at this time, in which if disputes arose in court, a legal question arose in court as opposed to a question of fact, they could pause the proceedings and refer to the question to the local law faculty, which responded. And there was some anxiety among law faculties that this privilege might get lost if in the design of a kind of set of national institutions, you were to come up with a different way of devising law applying institutions. And so part of what I suspect is going on for Savigny here is he wants to protect the autonomy of law. And for that, he needs a positive theory that justifies the autonomy of law, but he also engages in an act of something like intellectual cowardice and stands back from any sense, so long as you respect the autonomy of the law and the social position and the authority of law faculties, we will stay out of politics. So it has one function, I suspect, for people like Savigny, and then for others, there's just this very important question about what a national state might look like if they had it. And the legal theory that gets generated in one context has a particular kind of social power in Germany and comes, I think, then to affect other forms of normative theorems.
So, Hobbes and a unified, indivisible theory of sovereignty plays a large role in this story. But what if I were to posit the authors of the Virginia Resolves actually reject such a theory of sovereignty? And in fact, they have a notion of empire as confederal rather than unified. And to suggest that, it strikes me that the argument in the 1770s is actually, you get certain people saying, like the Prime Minister, Lord North, saying, yes, I believe in a Hobbesian unified indivisible theory of sovereignty. Therefore, you local colonial assembly, you can say what you want, and generally, if we think it doesn't conflict with our notion of sovereignty, you can do it, right? But it strikes me that there's an alternative theory of sovereignty, which is being enunciated not just by the Americans, but by the 46% of the House of Commons that rejected North's position, which is that actually sovereignty lies in the people, all of the people in the empire, and that's why we have local assemblies, so that you have popular governments in the localities. And then there's this problem: what happens if what the Assembly of Virginia wants and the House of Commons in England want? What if they conflict? Their theory is, well, of course, in any sort of confederacy, there obviously has to be some final adjudicator, and in theory, the king is neutral and is the king of all Britons, and that's why there's so much anger in the Declaration of Independence, because George III has not acted as an impartial arbiter, but acted as the defender of North's theory of sovereignty. So I guess what I'm sort of wondering is, because it strikes me that one way of thinking about this is that there's three possible positions, right? There's the Cook-Savigny position that the law is independent of government, that it comes from the people, or Cook's notion of whatever it is in the midst of time. There's Hobbes's theory of unified indivisible sovereignty, which comes from a theory of the state of nature in which exists in the war of all against all. There can be no property prior to the institution of government. And there's another, which comes from a Lockean tradition, which says, actually, there's property before government, and that property and government is. So I guess what I'm sort of wondering was whether there's three possible positions instead of two possible positions.
Yeah.
Because I think, I completely agree with your notion that we need to think about empire, because empire is the fundamental, is the most common form of government in humankind. So the question is whether there are multiple ways about thinking about empire.
Sure. No, that's absolutely correct. So I won't spend much time on, as it were, your articulation of the fair practice position, because people are, I totally correct. It's an alternative theory. I traced through one stand in part because some aspects of the story I was telling struck me as latent in at least some of the material, and we'll use other stuff to flesh it out. And I will add by way of reflecting on Hobbes, and it would be true if we read some of Baudin and some others, right? That their vision of two reflections on their vision of something like strong unitary theory of sovereignty, which is that it was essentially an erotic theory, right? That is to say, no state that they knew of, and no state for a very long time, had anything like the infrastructural power to realize sovereignty as they described it. They came by this longing, they came by this passionate desire for a strong sovereign, precisely as Hobbes makes clear through their experience of civil war, right? And in that sense, one would endorse Marshall Solon's once quipped about when Marshall was writing about Leviathan, that you have to have a lot of culture to have a state of nature, right? That you can only imagine a Hobbesian. You can only imagine a Hobbesian state of nature if you've had culture that's fallen away. So that's one thing. And I guess I'd add to your comment this a further alternative, which is that this toggling between empire and something else is part of that is to say that the concept of empire is important because there are these other contexts, the most important of which would be French, at least in the documents we're reading in the Democracy Core, right? In which it was possible for somebody to say the Declaration of the Rights of Man and Citizen has implications for Haiti because they are citizens and we figure it as a nation or whatever. And then other people, Barnave, to say, oh, no, we're not a big nation. France is a nation, but they're part of the empire. And the minute you insert the kind of the theoretical concept of empire, you get to say some parts of it are ruled by us, but are not of us. And that allows, I mean, a completely ridiculous and somewhat shameful and ultimately very, very rapidly a losing position about but there you go. I would add, and I suppose let me add one further item to the mix. I mean, the lecture went on plenty long, but I did imagine, by way of illustrating the way in which theorists can occasionally be forced to confront the untenable politics of their position. The account offered in section 4 of the introduction to Blackstone's commentaries on the laws of England. So Blackstone was a law professor, like the first to hold his particular kind of chair at Oxford, who wrote a book called The Commentaries on the Laws of England, first published in the late 1750s, reprinted many, many, many times. And in the introduction, section 4, he seeks to account for why the common law applies in various regions of England. And of course, the problem he has is he begins with a theory of legal imminence, that the common law is simply immanent in the practices of the people. And then he says, of course, English common law also applies in Wales and Ireland, because, oh, that's right, we actually just beat the shit out of them once upon a time. And he cannot say the common law is actually a body of law that you can apply by like killing people. So he then says about Wales, he says, well, yes, we conquered them under Henry, and it did take a very long time, Henry VIII, and it did take a very long time. But in the past, in like the mists of time after the Romans retreated from England and blah, 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 the princes of Wales bowed down at like fucking Stonehenge in front of somebody he names as king. And therefore, there may have been a period of hundreds of years in which everyone forgot this and they wandered off and did their own stupid thing. But they should have been subject to the English common law all along. And it was just a historical error that, this rupture in their practice of common law, which still doesn't explain why you enforce it back on them. And about Ireland, he has a demographic argument. I mean, it's lousy in terms of numbers, but in this text, he says, well, now that we've conquered Ireland, some English people have moved there. And insofar as their customs are immanent in their social practice, there are now people in Ireland. I mean, a tiny minority, but there are people in Ireland who follow the English common law, and that's why all of them are forced to do it. But he can't say that, that Great Britain was an empire and they used the common law because that's, we just made. So that would be another text of exactly this moment in which somebody has to confront the kind of conflict between, as it were, his a kind of a theory that's, I don't know, it's not quite democratic, obviously, but it, you know, it has a political valence that comes a cropper of state form.
I mean, I think you talked earlier about how you said, people are the source of law that might not be democracy. And that reminded me of, I mean, there's a general rule of thumb, I think, that a country with the words democratic and peoples in their name, in general, are dictatorships, right? We have the Democratic People's Republic of Korea, for example. And I mean, I just wanted to add, so like one, I mean, I saw earlier that in the excerpt from like the surrendering, it was like the Roman people and Senate. And so my first question is like, to what extent was it actually like part, like a decision of the Roman people? And my second question, which is weirder, but
To what extent did the Roman people actually participate in decisions by these commanders? In the
yeah,
field?
was it just like fluff? Well, I mean, like for example, I mean, like to take.
Yeah, I can give you a sort of answer, but go ahead.
I mean, my comparison in my head would be in China, everything's named like People's Court or like People's Government, even though like
Sure.
it's not. And my question is like to what extent was that anyway, sorry. But I'm not phrasing this really well, am I? But my second question-ish is that like, wouldn't the fact that like you have these countries like calling themselves like democratic like peoples, whatever, like wouldn't that by itself kind of like provide like, aren't they like kind of like hiding behind the people as a veneer of legitimacy? And like, wouldn't that like kind of support the fact that like law is like at least theoretically supposed to be?
Yes, so, yeah, I mean, the second point is simply true, but I'll offer you an example in a second. So let me take the questions.
Sorry.
No, it's totally fine, it's a great question. I'll take them in order. So first, there are various reasons to think, the Romans say, that when a commander returned from the field, he had to submit some account of what he'd done, and there was an organization of that. In point of fact, I don't know, last account, something like 100% of the time, of course, the people just accepted what people did. Among other things, because if some commander went off and did something nutty in the field, the Romans would have to deal with the consequences anyhow, right? What would it mean to say the whole thing had been unauthorized? But there was actually an occasion which the Romans decided not to authorize something. And in a sort of funny way, by way of arguing about it, they wrote a version of their history in which they'd done something similar in the past. It's the way a lot of Roman history was invented, was to argue that, oh yes, we went through this before. The solution we did prior was this. And that was so, the context is a moment in the later 2nd century when the Romans got into military trouble. And in order to save his army from being slaughtered in the midst of defeat, a Roman general surrendered and agreed to terms of surrender and then extracted his troops and went back to Rome. And of course, one of the things that distinguished Rome from all other polities was that it had something like inexhaustible supply of manpower. So defeat was never terribly discouraging for the Romans because they would just send more idiotic young people out there to die. And so the Roman Senate said, you know, Jim, you jackass, you know, why did you surrender? What are we supposed to do with this? We don't want to abide by the terms that you signed. And so they invented a doctrine that no treaty was binding on the Roman people that had been signed. And the Latin term they use is in usu populi. So the in prefix is negative, like invisible, and usu from the term eubeo, so without the command of the people. And this term in usu populi, or this phrase, appears in Roman texts for 50, 80 years before we ever find an actual declaration of the people have sovereign. That is to say, the original context in which the Romans ever articulated theory that the people were sovereign was in the context of debates about this tiny handful of instances in which the Romans decided to reject the actions of the commander. So you're right to send that out. But the thing is that they put forward the argument entirely speciously. And what they did on that occasion is, having saved 10,000 soldiers, they simply took the general himself and they said, we repudiate the treaty and we're going back to war. Thank you for giving us our soldiers back. Because Jim was not authorized to this, you can have one guy. They gave them one soldier and they got 10,000 lives. And then they just started the war again. So it was entirely pretextual. They didn't believe in popular sovereignty at all. It was just a way of getting around the problem. Oh, and the second, I mean, I think I told this story in class about the East German elections. Yeah, I'll just quickly, since I've bored some people with this before, I spent a bunch of time at a German institute in an institute in Germany in 2009, so on the 20th anniversary of the fall of the wall. And therefore watched a lot of German television in which people discussed what they called Ostnostalgie, both fond memories of the East German Republic, and also told stories in some history channels about the fall of the wall. And there have been local elections, I think in Turingen, in August of '89, I think it was Turingen. And they got two people on TV who had been TV commentators in the fall of '89, when the results from Turingen rounds, and these were commentators in West Berlin. And the East German news said that the party candidates had won these local elections with something like 85% of the vote. And since the party candidate almost always won with 97% of the vote, this was like a shocking development. And these guys sat there and they showed these clips of these guys on TV from 1989, and they said, well, actually, this must be a confession that the party is in deep trouble, that the vote they had lost the vote by some overwhelming margin. And they knew that at some level, everybody in this land knew that. And their way of admitting this and opening up a space in which they hoped then to solve them. I mean, the wall fell very soon whatever, but their mechanism for acknowledging the unhappiness of the people and creating a space in which they could then in following weeks say, Cliff has obviously lost the confidence of his people, and we're sending him to Siberia for re-education, and we're going to give you people a new mayor or whatever. Their mechanism was to admit that we'd faced this shocking loss of support of down 15% negative vote. And in one of these, the guy was asked. He actually became the rector of one of the universities in Turingen not so long after I was there. One of these guys was on TV, was asked, does this mean that the East German political system is weak? And he said, I fully expect it to fall, probably not in my lifetime, but soon, but eventually, but it fell 2 months later. But that was a case where, also, another joke along these lines, an Israeli friend of mine, who should be invited to all academic conferences. He was a teenager who grew up in the Soviet Union and was just so violent that and he was also a Jew. He was so violent that eventually they threw him out of the Soviet Union because he was just unmanageable. And he went to Israel and rowed crew on some Olympic team, which is very difficult because I think they do it in the Dead Sea. So actually you have to move all this salt. And then he became an academic. So his store of Jewish, Russian, Israeli academic jokes is really inexhaustible. But the most memorable one he's ever said to me was, when was the first Soviet election? And the answer was, when God presented Eve to Adam and said, pick a one. Any other? Yes, sir.
Was the origin of the term democracy?
Yeah.
Is there a history of it being rhetorically mobilized by fascist intellectuals and anti-fascist intellectuals? Because it seemed like the notion of domination by the poor could both turn up in the Communist Manifesto and turn up in a brief from the Federalist Society on behalf of Trump's anti-democracy.
That's a question that I'm sure there are people in the audience better qualified to answer that than I. I mean, my own sense is of essentially late 20th century theorizing is that most people think of democracy, in a Roman style popular sovereignty sense. And it, as its were, these Greek roots in which the demos is actually only part of the people, it's not figured in a lot of modern theorizing about democracy. So I doubt it, but I don't know. I mean, there are strands of ancient politics which are widely debated. So like, the late medieval and modern anger about so-called agrarian laws, that one of the things you do if you have a strong democracy is they're continuously trying to expropriate private property. That is something that is an aspect of the ancient history of democracy, which gets wildly bandied about, completely divorced from the actuality of what ancient agrarian laws were trying to do. So
I didn't mean to Greek, I did mean to Greek.
Yeah. So what I just mean is that there are aspects of ancient democracy which are seized upon by conservative critics, but I'm not sure that narrow aspect.
I do wonder if one of the reasons is that fascists, as far as I understand, generally do not like to actively openly dissociate themselves with the poor. If they're going to be doing a kind of pseudo populist group, they tend to not want to explicitly, openly shit on the poor, if you will. That's my.
I wonder if you could explicate for our audience the relevance of your argument to the Numerous documents that outline natural rights or rights. Pick any one of them, but the Bill of Rights, the Declaration of the Rights of Man and Citizen, the Bill of Rights added to the Constitution. What work do you think they're doing within this cynical framework of imperial co-optation that you've outlined?
Oh, I see.
What's the point of granting rights in that framework?
I mean, I really, I don't even know people in the room who know more about that. I mean, here I'll say, that the development of the long history of the use of the term nature in this context is actually kind of interesting because it comes to mean some, in that sense, nature being a place in which one locates rights, as it were, as metaphysically distinct from and prior to the state, at least potentially, as it were, prior to the state, is a very modern phenomenon. In the ancient world, the term natura in Latin, as used by legal theorists, refers to, in essence, to social reality. People are always doing things in natura, and then ending up in courts as a result of this. The term nature does not mean something outside the walls of the polity. It's not a topographic thing. Neither is it in opposition to the oikoumene, the inhabited. So that term natura, and therefore it's so long as legal theory is conducted in Latin, it's very hard for it to escape that. The term nature it requires some violence to come up with a modern theory of nature in opposition to a political or instituted life, in which you then posit something. I mean, my own instinct, but as I say, this is just by way of giving an obvious answer to the question, is that like as Steve gestured at Locke's insistence, which of course is also an Aristotelian insistence, that it was possible to have social life and private property antecedent to the state, which has these kind of interesting effects in both Aristotle and Locke for what you imagine the state, what you imagine the most useful functions of the state to be. If you don't need a state to defend your very existence, if you can have existence and social life and private property without the state, then all sorts of, that you need a pretty minimal state. And the things you would surrender to the state by way of power are small. But Locke and a bunch of others, I mean, all these characters, they're as with you can see Cook doing this with the common law, that in order to resist royal power, either at the level of lawmaking or for that matter of the application of law, the assertion that the actual source of norms, that norms were immanent to the people, and that the people were, you know, as it were, metaphysically prior, justifies a resistance to state power. And my very simple reading of these invocations of nature is it's not unlike invocations of God, that it's just a way of establishing a metaphysical position or granting an ontology to a set of rights that is prior, and therefore, among other things, that it successfully establishes resistance to state power. And that's the order. I mean, what these people are not talking about when they talk about rights are, of course, defenses against intrusions of state power, not Hofeldian subjective rights, for example. So no one, these other concepts of rights, that is Hofeldian subjective legal rights, are never described as originally in nature. You don't need the concept of nature for those rights. But that's that ain't my field. Steve looked very skeptical. I wasn't going to answer the question. I think I'm entitled, since I'm the one standing, to say thank you very much. And let you go.